Good day to you. This is Graham Paddock with a Paddocks Club tutorial designed for trustees. The situation that I want to examine today falls into the category of administrative management in a sectional title scheme. The question is, what should trustees do when they suspect, or when they are told, or even when they actually believe that they know that a scheme rule is not valid and binding, and the converse, when they believe that a scheme rule is valid and binding, but somebody else says that they believe it's not? Well, this falls into the category of questioning of validity of scheme rules. And the problem may arise in a number of ways. Some owners may challenge a rule. It's not unusual for owners to say things like, this rule is unreasonable, and because it's unreasonable, it's invalid. Now, when this sort of thing happens, it's very often the case that the owner feels that the rule is unduly restrictive of that particular owner's rights to do something that they want to do. For example, a rule that is a total ban on pets. An owner may say, well, what about my collection of goldfish? How can you possibly say that that will disturb anybody else or mess anybody else's life up? It's just unreasonable, therefore it's invalid. And you might think, well, you know, there seems to be some logic in that, but my job is to enforce the rules, and I must do that as they stand. Another situation is that you may get evidence that indicates that a rule was irregularly made. It does actually happen in practice. Records may show that the trustees signed a Form V, for example, without the necessary authority. And in that situation, as does happen in actual practice, a managing agent may be involved but may have drawn the Form V on the basis of a clear instruction from the chairperson that there was, in fact, a special resolution taken. Chairpersons have misunderstood the requirements for special resolutions and been convinced the decisions were properly taken. Sometimes when they've been particularly interested in the result of that decision, it must be said. But later you'll find opposing owners check the attendance and voting records and find that in fact the special resolution wasn't taken. Another example may be when the deeds registry records show no evidence of the making of a rule. There should always be some evidence in the deeds registry that a rule has been properly made, either by the developer on the original submission and the opening of the sectional title register, or later by the body corporate, and that will be evidenced by a form signed by trustees showing the new rules that were made. But it may happen that you go to the deeds registry and you find absolutely nothing. It's also happened that notifications have been irregularly removed from the deeds registry's files. So in these circumstances, what should the trustees do? Well, I suggest that the trustees must understand that the law does not expect them to be legal experts. If they happen to be attorneys or advocates, of course, they will bring their specialized legal expertise to the party. But in situations where they are not legal experts, they don't have to pretend to be that. The Sectional Titles Act makes specific provision for bodies corporate to use the services of experts of all types when that is necessary. But what should you do? Ask the managing agent, if you have one, for advice. He or she has probably dealt with similar situations in other schemes, and they may well be able to give you sensible advice. Get outside input. Raise the issue in the Paddocks Club discussion forum. Ask for my view on the issue. Get the view of other members. And if it becomes necessary, get a legal opinion. Discuss the matter at trustee meetings. It's not just one person who must make this decision, and it shouldn't just be a few. The chairperson talking to one other member saying, oh no, this is complete rubbish, or of course the rule is completely valid. That's not the way it should be done. It should be raised and discussed at trustees meetings, and the trustees at those meetings should decide what they believe is correct on the best evidence available, and then they should minute that decision. Also, if there's any uncertainty at all, consider taking the issue to the next general meeting. And remember that it is possible for the general meeting to make a new rule, make a different rule, change the wording so that it's not unclear, or if a rule has gone missing, to make a new one that replaces it. Also remember, if the uncertainty remains, that in terms of Section 39(1) of the Sectional Titles Act, you can ask the trustees, or the trustees can give you a specific direction, which would then be minuted. One way or another, the decision should be minuted. So if you believe that the rule is valid, then say so. On the best advice we have, this rule is valid, so we're going to enforce it. On the other hand, if you think that it's invalid, then say so. In the minutes, we believe this rule is invalid, and therefore we're not going to enforce it. At the same time, you could consider motivating an amendment to the rules to cure the problem, and if somebody is still unhappy, invite them to start a process, to start arbitration on the issue. In due course, when the Community Scheme Ombuds Service Act comes into effect, which is expected to be sometime in 2012, an adjudicator acting for that service will be able to change scheme rules or to overturn a scheme rule which is found to be unfair. I hope that this has been useful to you. Thank you for joining me in this Paddocks Club tutorial, and I hope to hear from you in the discussion forum.